So a lot of times people have questions about what is an operating agreement and whether or not I need an operating agreement. An operating agreement it's a particular document, and it exists in a limited liability company. Similar to a bylaw in a corporation or a shareholders agreement in a corporation, which they're very similar documents. This is a critical document in my opinion, and I think that you absolutely need it. So as a matter of law, virtually every state that has corporations or limited liability companies have a set of default rules that if you don't have one of these documents, these are the rules that everybody has to follow. The problem with those default rules is that it may not meet anybody's expectations, either sides, any of the shareholders, any of the members of the LLC, and so it's really important that you take the time to have an operating agreement. What's so important about an operating agreement is that it allows you to set expectations up front, right? It deals with the 5 core issues that every corporation, every business entity, and the owners have to be thinking about, including the division of equity, right? Many people think about that. They're like, hey, you're gonna be a third, I'm gonna be a third, and Bill over here, he's gonna be a third. But equity division can operate differently. There's different ways of dividing things. Sometimes people are gonna do more or less inside of a company, and maybe a year or 2 years down the line, someone could be bought out. You really wanna be talking about things like equity division, and that's usually discussed inside of an operating agreement. In addition to that, there's also ways to treat the intellectual property, right? The innovations of the business. Talks about how decision-making is done. And most of the time, businesses, right, whether you're an LLC, whether you're a corporation or some other business form, falls apart because expectations aren't being met. So one owner thinks things are supposed to work this way, one owner thinks things are supposed to work this way, and then a conflict develops because they go, wait a second, my expectations aren't being met. And the other side goes, wait a second, my expectations aren't being met. And the best way to avoid that is to have the discussion and then to boil down that discussion into an operating agreement that everybody signs, everybody agrees to, and if there's ever an issue, you pull out the trustee operating agreement and you go, do you remember on December 12th, when we talked about this, we discussed this issue that decision-making would be done like this, or the equity division would be done like this. And here's the operating agreement, it discussed this, and if there's ever any conflict, courts usually resolve the issue with what the operating agreement says. So even if there is a dispute that ultimately arises and for some reason someone's interpreting things one way or somebody's interpreting things another way, courts are going to usually resolve it by way of the operating agreement or a shareholder agreement. And so it is critical that you guys have one whenever you're forming a business, whether it's an LLC or in the form of a corporation, a shareholder agreement. So if you have any other questions or want more information about this, you're welcome to contact us at Callagee Law. I'm Michael Smikin and I'm here for you.